Well, hello everyone. We shall be making a start now for one of our Minimising Risk webinars. Today we are on the subject of disciplinary investigations. A warm welcome to you all and thank you for joining us today. We shall begin by making our introductions as always. My name is Abby Ashford, Senior HR Advisor and Customer Support Manager, and I shall be the lead presenter today. I am joined by my colleague Sue, who is here to field any technical problems that there may be, hopefully none. She will be monitoring and collating questions, so do send her a message if you wish to. If we have time at the end to answer any questions that may be relevant to most, then we shall look to answer them, but otherwise I will email you a response after the webinar. We will be recording the session and slides will be made available on request afterwards. This is what we shall be covering today in our webinar on disciplinary investigations. I will begin with an overview of the subject matter before moving on to the rights of employees, then how to ensure that you follow a fair and legally compliant process, before turning to the topic of suspension, and finally looking at alternatives to suspension. It is good to start out by thinking about what we are trying to achieve. By the end of the webinar, you will hopefully feel we have met these aims. To feel more comfortable with practices that should be present in all robust investigations. To know how to run the perfect investigation meeting. To equip you with practical tips that you can implement to minimise risks of getting an investigation wrong. And so, an overview to start our webinar today. Investigations are often thought of as the easy bit, yet it is surprisingly common for dismissals to fail in tribunal because an inadequate investigation was carried out. Investigations must inform the content of a disciplinary hearing, so if they are not robust, employers are already at risk of a potentially unfair process. All the evidence must have been shared with the employee prior to the disciplinary hearing, so that they have adequate chance to prepare for the questioning that will take place at a hearing. Don't have TV show police dramas in your mind when planning your investigation. You shouldn't plan to withhold evidence to surprise employees with at hearing stage. You must reveal everything that you want your employee's response to at investigation stage. This may mean more than one investigation discussion as evidence comes to light. If you find yourself in a position where you thought the evidence pack was complete and it has been sent out with the disciplinary invitation letter to the employee, don't worry about pushing the hearing date back if you find more evidence that is pertinent to the case. Better to do this and have a thorough investigation than force through new evidence that the employee has not had time to prepare with. If that employee has more than 2 years service, you could find that you have made a procedural error that can lend weight to an unfair dismissal claim. In reality, I have had situations where, as a hearing is about to start, new evidence comes to light, and I have asked the employee if they are happy to look through the new evidence and to push back the hearing start time. If they are in agreement, this can be noted in the hearing minutes, and the hearing can then still take place the same day. So there is usually a workaround, as long as you are transparent and fair. In a nutshell, investigations are a fact-finding exercise only. There is no blame at this point, no opinions are being formed, and no formal outcome is issued off the back of an investigation. It is important to establish the facts and circumstances that surround issues in the workplace when they arise. This is why it is important at this stage to ask as many questions of the more relevant people involved in order to gain enough information to decide whether a disciplinary hearing is appropriate. Many first-line managers, when they decide or are told that a matter needs investigating, focus on detective work surrounding the issue and forget to take a statement from the main employee involved. So if you were tasked with investigating a potential disciplinary matter, it is worth planning who you need to speak to and what information you need to gather. Depending on the situation, priorities may be obvious. For example, if there was CCTV in the area where an incident happened, this footage would be a priority to secure before it was recorded over. If the incident involves physical behaviour, then the immediate need is separating the parties involved, taking their statements of what happened whilst it is fresh in their mind, and then deciding if suspension is required. Investigating will help to identify whether it is appropriate to take further action, and if so, what form the further action should take. As sometimes after investigation, you will find that there is no substance to the original concern and no disciplinary is required. Or perhaps instead of disciplinary, a counselling conversation or informal discussion is all that is required. The issue will typically fall under one of the following umbrellas: conduct, which is managed via the disciplinary process; capability, which is managed via performance management processes; and then medical capability, which obviously is managed via medical capability processes, but all different. Most workplace issues that need investigating tend to relate to an employee's conduct. So during the investigation, be alert for any cues which point to the nature of the problem and subsequently what the most appropriate method for dealing with it might be. As above, it may not always be that a disciplinary route is the most appropriate form of action. Let me just touch on the subject of absence management here, as sickness can be dealt with under any of the three areas bulleted on this slide. Persistent short-term absence can be managed by the conduct route, and the investigation stage would generally be the return to work interview when the employee came back to work, asking them about their absence, talking about their absence history, and if already been warned before that an improvement was required, the next stage would be a disciplinary hearing. Absence also falls into capability, more so medical capability, where an employee perhaps is no longer able to fulfil their employment contract due to their health. The investigation stage in these circumstances would be from welfare visits and from medical reports. Employee rights is a useful section. And because you might find this yourself, I'm very aware outside of work that people are increasingly aware of their rights in employment. However, they are not always correct in their views. They just know they have rights. And often you will find someone is related to or has a friend who is a solicitor, or perhaps works in human resources, or maybe they've got ACAS on speed dial. I have often heard in conversation where a person is being disciplined at their work, an individual saying that they've perhaps been invited to a hearing without any investigation prior, and the sympathetic listener responding with, "That's out of order. You have the right to attend a disciplinary investigation meeting. You should have been invited to one, and you should have had the right to be accompanied." You may also have been in this situation. So let's now look at what exactly are employees' rights when it comes to the disciplinary investigation stage. And let me just underline that we are talking about dealings with your employees. If the person that the allegations are about is not an employee, for example, an agency worker, then it should be their employer that holds the investigation meeting with them and not yourselves. Generally speaking, there are no statutory rights to be concerned about at this stage of a disciplinary process. It is an employer's prerogative to have a conversation with their employee about any causes for concern. However, this is often one of the reasons why employers may think this stage is straightforward. But there are several other factors that need to be considered which may determine certain aspects of how an investigation should be ran. Sometimes a company's internal employment policies, such as a disciplinary policy, state how an investigation should be ran and what the employee can expect to happen. You may not have a disciplinary policy, in which case you should follow the ACAS guidance. However, if you do have a disciplinary policy, you should adhere to it to ensure that employees are being treated consistently with one another and that managers are consistently applying the policy's contents. Failing to do so can lead to distrust, grievances, and in worst case scenarios, risks of discrimination, even if this was not your intention. Taking it one further step, if your disciplinary policy is contractual, then failing to follow it can immediately give the employee the right to claim compensation for a breach of contract. To find out if your disciplinary policy is contractual, you can check the policy itself. Usually at the beginning, it will state whether it is contractual or a non-contractual document. You can also check the contract of employment in any clause that mentions company policies or specifically the disciplinary policy to see whether it says that the disciplinary policy or all HR policies are part of the contract of employment. Some organisations have an employee handbook. If you do, and this incorporates the disciplinary policy, again, check the contract, check the handbook to see whether it determines the disciplinary element as contractual. We also have to consider any customs and practices that have developed and if they have to follow these. So, even if you don't have a contractual disciplinary policy that states you always invite employees to an investigation meeting, even though it isn't a statutory right, if you have gotten into the practice of always inviting employees in for an investigation meeting, then this becomes a custom that you must continue or break. It is also wise to reflect on any investigations that have happened recently and to mirror what happens there, bar any mistakes, of course. Your employees will talk to each other and they will remember what happened, and you can pretty much guarantee they will want to have been treated the same. As mentioned previously, consistency is extremely important, as failing to be consistent can lead to distrust, and sometimes it risks discrimination. What's more, custom and practices can become implied terms. These can carry as much legal weight as a contractual term. Consideration may need to be given to equality law. For example, are there any reasonable adjustments that may need to be made to support the employee in order to make the investigation process fair. You may have an employee who needs help with translating to ensure they understand the allegations and can adequately explain to you their side of the story. You may wish to allow an employee under the age of 18 to be accompanied by a parent or guardian. If an employee under investigation is off sick with a mental health condition, it may help to conduct the investigation interview at their home, relaxing the accompanying person definition to allow a relative to be there for support. Remember, you are tasked with listening and probing to gain the facts of the matter, and to do this, the employee needs to feel that they can open up. So anything that you can do to assist with this process will help you to do your job as investigating manager. Some regulatory bodies may impose requirements at disciplinary investigation stage. For example, GPs are subject to robust protections. Similarly, some local authorities may have special rules for young workers, but nuances such as this amongst local authorities rarely crop up. So if you are subject to any, then double check the requirements. A summary of employee rights then, when it comes to disciplinary investigation before we move on. Investigations are often thought of as the easy bit, yet it is surprisingly common for dismissals to fail in tribunal because an inadequate investigation was carried out. If you are the manager assigned to chair a disciplinary hearing and you don't feel that the investigation stage has been thoroughly completed, it is better to rectify that than plough ahead and have to correct a procedural error at appeal stage. Investigations must inform the content of a disciplinary hearing, so if they are not robust, employers are already at risk of an unfair process. Remember, an unfair process that leads to a claim for unfair dismissal can only be made by employees with over 2 years' service. However, if an employee has received unfair treatment in relation to a protected characteristic, they can attempt a discrimination claim without the requirement for 2 years' service. Next, we will look at various aspects of an investigation that are important to get right. I will be focusing on investigation meetings specifically. After all, these tend to be where many errors occur and where quick wins can be achieved. When to hold the meeting. Note that the ACAS guide says that it is not always necessary to have a meeting. Perhaps you've already held a return to work interview for someone with high absence and there is no extenuating circumstances to prevent the inevitable disciplinary hearing. Or perhaps you have a contractual clause stating that the full disciplinary procedure will only be used for those with over 2 years' service. However, if something has happened which gives cause for concern that you want to investigate and the situation is not minor enough to sort out informally, then there should not be a delay in holding an investigatory meeting. Allowing time to pass without addressing the issue can mean that the conduct is taken to be acceptable. According to the ACAS code, which we abide by as it is what tribunals use as benchmark, there is no fixed timescale. It just says without unreasonable delay. So unless your internal policy fixes a timescale, there is none. Investigating managers must consider interviewing the employee or employees who the allegations are about first, before witnesses if there is a chance that the matter will leak out. This situation can lead to the employee, who may actually have done nothing wrong, feeling very disgruntled with their employer and cause bad feeling. If you have evidence such as till receipts, CCTV footage, customer complaints, stock shortage, and you want to know whether an employee is involved in the issue, Ask to speak to them privately as soon as possible, as they may be able to provide a simple explanation that allays your fears, or may be able to point you in the direction of someone who is more involved than you had originally realised. Notice. There is no legal requirement to give notice of a meeting such as this. Unless you have a policy or practice which requires you to, it is often best not to give notice, as this lends itself to demonstrating the informality of the meeting, and it is often best not to give individuals time to worry or deliberate over their answers at this stage. However, if you do have a policy or a custom and practice in place, which would mean that an employee may expect to be given notice of an investigation meeting, then this would take precedence. If you don't, it is perfectly acceptable to ask someone to come to a discreet meeting room to have a conversation. If they ask what about, say that it is something you want to talk to them about privately, and only start discussing the concern once they are in an area that others cannot hear. This task is usually assigned to the individual's manager, unless that person is implicated and cannot be impartial in the proceedings. The right to be accompanied. Employees do not have the statutory right to be accompanied at an investigation meeting. In some cases, employers may have a company policy to allow a companion. Alternatively, it may be custom and practice in your organisation to allow this. But if you do not give the option of an accompanying person in a policy or through precedent, then you do not have to offer an employee the ability to bring into an investigation meeting a fellow worker or certified trade union representative, like you would at a disciplinary hearing. However, you do have to also consider reasonable adjustments should an employee request one. For example, as I said earlier, it would be reasonable to allow employees under the age of 18 to be accompanied by a parent or guardian. Attendees. An investigation is between the individual being asked questions about the matter of concern and the manager who has been assigned to investigate. There will usually only be these two people in an investigation meeting, a maximum of 3 people really, if a note taker is required too. A note taker is not essential, and if you feel the third party will hamper the individual opening up to you, then this can be done on a one-to-one basis. Just ensure that you ask the employee to pause where you need chance to write things down. The investigating role. Bear in mind that whoever holds the investigation meeting, a different and more senior person will need to hold the disciplinary hearing if one is necessary. Therefore, in terms of planning for the whole process, it is worth considering upfront who will investigate, who will chair any disciplinary hearing that is required, and if the employee appeals any disciplinary outcome, who is your most senior person not involved in the process that can be held back to chair any appeal that is submitted. If you are a very small company that simply does not have 3 separate manager roles to assign these 3 stages to, if possible, you should have one person investigate and hold the disciplinary meeting and hold a further person back to chair any appeal. Each stage is meant to be a fresh pair of ears and eyes, you see, for fairness. The note taker. If you do have a note taker, they should not speak during the meeting except to ask for a pause or to ask for what was said to be repeated. Okay, so your approach. The tone of the meeting. It must be exploratory. seeking only to find the facts of the matter and to clarify the employee's explanation for what happened. You aren't starting from a position of guilt to see what they have to say about it. You want to explore the concern that was raised, looking for evidence that supports the employee or that supports a case against the employee so that you can get to the bottom of what has happened. If you have evidence to show the employee at investigation stage, do this in the meeting, especially if it is not something that can be easily provided as a copy to take away. For example, CCTV footage. Show this at the meeting to gain their response. It can always be shown again at the hearing. Seeking clarity is different from being accusatory. The latter can come about in a disciplinary hearing. There is a distinct difference between these two, which can have a significant impact on what the actual purpose of the meeting is. It also must not appear as though a decision has already been made, as this can render any subsequent action as predetermined. I believe this takes some of the pressure off for a manager designated to investigate, as they know their remit is not to decide on a disciplinary outcome, but purely to complete a fair investigation only. Minutes of the meeting. Where meeting minutes are taken, we recommend that you start with the date, time, and who was in attendance detailed at the top of the page. It is best to quote what the person being interviewed says, and even note down if something non-verbal happens and is of relevance. Details and the language used can become important when you are documenting how somebody felt about a person. So it is crucial that the minutes are as detailed. The initials of the speaker should sit alongside. And here's an example. If an emotional reaction tears, which is quite common, jot this down. It helps when you pass on the evidence pack to the disciplining manager that they can see how the employee felt at investigation stage, as they will need to plan their disciplinary hearing questions accordingly. And it is their role to ultimately decide whether an action was taken maliciously or in error, for example. It is worthwhile allowing some time at the end of the meeting for the employee to review the minutes and to sign each page. If your writing is legible, this can be done straight away and a photocopy given to the employee. Alternatively, you can explain that you will type up the notes, or your note taker will, and a copy will be provided for them to sign that it was a true account of what was said. If the employee disagrees with the content, then either an agreement can be made to amend the minutes, or notes can be made and kept alongside the original document. With recordings, if you do wish to record the meeting, the employee needs to have agreed in advance. It is worth confirming their agreement again once the recording begins, so there is evidence of this agreement. Recordings are a more accurate record than minutes, but they do mean someone may have to transcribe them. Tribunals will only accept written transcripts, by the way. Querying extenuating circumstances. Sometimes issues may come about because of a sensitive underlying cause. This is not always something an employee is readily willing to talk about, but scratching the surface may uncover details which significantly alter the appropriate course of action. For example, someone may smell of alcohol, but they may be taking medication for a disability which causes this smell as a side effect. If you are not aware of any possible extenuating circumstances, Ask something generic, such as, is there anything else going on that I should know about which may have caused this to happen? Be on particular alert for reasons connected with the Equality Act or statutory rights, such as health and safety. By asking this question, you are exercising your duty of care and significantly minimising the risk of anything contentious causing problems later down the line. Extenuating circumstances, of course, aren't a guaranteed way of getting out of a disciplinary situation. You may find someone being investigated for theft admits they are having terrible financial issues. It doesn't mean that the behaviour is excused, but it does explain why it is happening. A further point of interest, if the case becomes a police matter, unless they advise you otherwise, you are able to continue with your internal investigation concurrently, as your process does not have to result in a decision of guilty based on evidence beyond reasonable doubt. As an employer, you are merely working with the boundary of whether on the balance of probability that the employee has committed an act of misconduct or gross misconduct. So it's very different. Decision time. Do not make a decision. A decision to issue a warning or a dismissal should not be made during an investigation meeting. At most, it may be appropriate to conclude that there is a need to progress to a formal disciplinary hearing and that they will receive a written invitation. However, this news is usually communicated to an employee after the investigation meeting, once there has been time to properly deliberate. What should happen after an investigatory meeting is that the manager leading the investigation progresses and completes the investigation process as a whole. He or she has to ensure that they have collated all of the facts, took statements from anyone involved, be they the employee, accused of the disciplinary act, statements from any witnesses, perhaps customer complaints, or copies of company rules breached, CCTV footage or vehicle tracker information, or perhaps just a return to work interview and absence records, depending on what sort of situation they are dealing with. They then have to ensure they have covered off the suspension angle, which we are about to move on to. And then they have to pass on all of this information to the manager, who will be chairing the meeting if there is to be a disciplinary hearing. This does not have to take the form of a report for the disciplining manager. It can be a verbal process and an exchange of information. Our final element of the investigation process is suspension. Firstly, let's remember why we suspend. The ACAS guide references situations where employment relationships have broken down, or where there are risks to employees, employers, or third parties' property. Suspension may also be instigated midway through an investigation if it is revealed that an employee is tampering with evidence or pressurising witnesses within a disciplinary process. Suspension is used when something is potentially gross misconduct. This means that if proven, the likely outcome is dismissal without notice, regardless of whether or not the individual has any live disciplinary warnings on file. Gross misconduct centres around trust. We are essentially saying that the conduct is so bad that we cannot possibly trust the individual to continue working here for a moment longer. And this is why suspension is usually a necessity in gross misconduct cases. Suspension prevents the individual from being able to repeat the gross misconduct again, whilst internal procedures are dealing with the ins and outs of the case, i.e. the investigation and potentially the hearing. A preliminary investigation meeting is advisable. This is because it may be that a brief conversation can quickly highlight that the matter is not gross misconduct, and in this case, the need for suspension may be avoided. This may simply take the form of a documented discussion. If following this there is still some doubt over whether a matter is gross misconduct, then suspension type measures should be put in place immediately and confirmed later in writing along with a brief reason. Arrangements can then be made for a robust investigation meeting to take place in the near future. In all cases of gross misconduct, the individual concerned must be placed on suspension, or alternatives to suspension must be put into place the moment you become aware of what has happened. Ideally, an investigation meeting would happen before a suspension. However, gross misconduct matters are usually complex, and it is rare that a robust investigation can be carried out at a moment's notice, not only because additional evidence may need to be acquired. Therefore, you may have some situations, such as a physical situation, where the individuals are suspended and then asked to come and have an investigation meeting to give their side of the story. In other situations that are less frantic, such as, for example, theft, you are more likely to ask the person to come and speak to you so that you can investigate before you make the decision to suspend. Be mindful that periods of suspension should not continue for any longer than necessary. Practically speaking, if you have had to immediately suspend and then invite to come in for an investigation meeting where there is no response, you will have to try other attempts to gain the employee's statement. Ensure you have exhausted all contact methods before writing to offer options such as a telephone investigation interview if they can't make it back onto the premises, or a visit to their home to conduct this activity. Alternatively, you could offer the ability to write or email in with their statement if communications have broken down quite badly. Document all of your efforts to show how considerate you have been as an employer. I have had circumstances where all efforts to conduct an investigation meeting after suspending have been exhausted, meaning that the disciplinary invite has had to be sent out, containing all evidence but the meeting notes of any investigation with the employee accused of wrongdoing. Offering the employee the ability to email or post in their statement in response to the evidence pack that can be read by the disciplinary manager prior to the hearing if they wish to. Moving on this topic, there are a few noteworthy points on suspension that I'd like to make. Suspension is always on full pay unless there are extreme circumstances, such as a person not having the right to work in the UK and where it would be illegal to continue paying them. The terms of the suspension should be confirmed in writing, either to take away with them or to be posted on, depending on how the situation plays out. The letter can confirm that suspension is not a disciplinary sanction and will not be protracted for any longer than necessary. You can also include restrictions on who the person can contact at work. I also find it is worth checking a person's contact details before they leave your premises so that there are no excuses further down the line that a letter wasn't received or a phone call wasn't possible because the company had old details on record. A few other practical tips are to consider equality if suspending and there are more than one person alleged to have committed a disciplinary act. For example, a male and a female have a fight at work and only the male is suspended, you might have incorrectly assumed that the female was the victim, and the male party can feel they have received detrimental treatment. Also consider your duty of care as employer. Continuing the example of a fight, if both parties are being suspended, don't ask them to leave at the same time. Bring one in to cool down and perhaps take a statement from them, and ask the other to wait in a separate room to be dealt with afterwards, so they are not leaving together at the same time, else the fight might continue outside. It is also worth considering whether a person suspended is escorted from the premises so that they do not have chance to speak to potential witnesses, scare them off from revealing their input, and do not damage any company property as they leave. Alternatives to suspension. If you recall, we mentioned earlier that suspension prevents the individual from being able to repeat the gross misconduct again, whilst internal procedures are carried out. Case law suggests suspension is not the only way this can be achieved. In fact, alternatives seem to be preferred and are becoming more widespread. It seems tribunals consider employers may be too quick to place employees on suspension, and that such a drastic measure can damage the employment relationship irrevocably if misused, which in turn could lend itself to employees resigning and trying to claim constructive dismissal if they believe that suspension was disproportionate and they have 2 years service or more. So let's have a look at what else may be an option. The form an alternative to suspension may take can be very dependent on the circumstances. Example 1. A carer is alleged to have administered medication incorrectly. Instead of suspension, the carer may be placed on temporary office administration duties. In this situation, the carer is unable to repeat giving the wrong medication to anyone. The employer hasn't been seen to punish by using suspension, and instead, especially for someone on a 0 hours contract, they are still able to work. Example 2. An office-based employee is alleged to have been physically abusive to a colleague. Instead of suspension, arrange for the individual to work from home. In this situation, the employee is unable to repeat being physically abusive to anyone. Although, of course, there would be suspension measures in place so that the individual knew that they couldn't, for example, harass the colleague they'd abused physically by other means, such as by phone, by email, or social media. Let's summarise what I've taken you through today. Hopefully you will have taken from my webinar an understanding that your remit is to fact find, to collate all evidence, to take statements and interview relevant parties to decide whether suspension is necessary and to pass on all information collected to the disciplining manager. Also, that if your company has a disciplinary policy, you should have read it and abide by it. You should use it to plan your investigation and who will play each role as the disciplinary matter is attended to. We looked at the fact that there are no statutory rights at investigation stage, but that you must take into account any discrimination risks and if an employee asks for a reasonable adjustment, this should be considered. I mentioned that if you don't have a disciplinary process to follow, that you should at least stick to the ACAS guidelines. If not, follow your process, and if it is contractual, follow it to the letter to avoid a breach. The main process points we went through were that no notice of an investigation meeting is required, accurate notes should be taken, and that the right of accompaniment does not kick in until the disciplinary hearing stage. In terms of suspension, I clarified that this is almost always paid and not used as a form of punishment. It will normally be used in cases of potential gross misconduct and will either happen immediately for situations that blow up very quickly or after an investigation meeting where a more considered response is able to be made. Finally, I opened up the topic of suspension to provide instances where an alternative to suspension can be considered. At our next webinar in November, we will explore the next stage in a disciplinary process, the disciplinary hearing. If you have found this webinar on disciplinary investigations useful, I would recommend that you follow up with the November webinar too. But thank you for taking time out to listen to me today. I do hope that you have found it interesting and useful. In terms of questions, clients, please do contact us in the usual way. And if you aren't a regular client with us, but would like to ask a question or are interested in our services, then please do contact us at inquiries@hrsolutions-uk.com. Here are some of the ways that you can connect with us via LinkedIn, Twitter, Facebook, YouTube for our webinar recordings, and also Google+. Our website address at the bottom there has a menu where you can locate all of our recent webinar recordings. Thank you for tuning in today as I sign off from the first part of our disciplinary suite of webinars on disciplinary investigations. Thank you.